Recording has begun. Good evening. This is the December 30, 2025 special meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force of the City and County of San Francisco. The time is 4:44 p.m. The Sunshine Ordinance Task Force and its committees convene in hybrid meetings that allow for either in-person attendance or remote participation. Public comment will be taken on each item of the agenda. Meeting decorum. Any member of the Sunshine Ordinance Task Force or its committees can call for decorum due to the disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Members of the online community, please note, we are not utilizing the chat function in WebEx because it is not visible to members of the public who are attending the meeting in person or attending by telephone. If you want to be recognized when public comment is called, you can raise your hand in the app or press *3 on your telephone to be recognized. Chair LaHood, that completes my announcements.
Please call the roll.
Item 1, call to order, roll call, and agenda changes. Taking the roll. Chair LaHood.
Present.
Chair LaHood, present. Member Wolf.
Present.
Member Wolf, present. Member Pilpel. Member Pilpel, absent. Member Anderson.
Present.
Member Anderson, present. 3 present, 1 absent. We have a quorum.
Please call the next item.
Item number 2, approval of the August 26, 2025 Compliance and Amendments Committee regular meeting minutes.
Okay, members, let's take a look at these. Does anyone have anything that they would like to recommend changes for?
Please note
I
that
believe these were ones that that we had additional changes on. Is that correct? That you had already received? These were we have 2 sets of minutes here on the agenda.
yes, I thought it was because the August minutes had not been presented before. There were, oh dear.
It's okay. I'm trying to remember. I might be confusing with a previous task force meeting.
Would you like to continue the August 20?
No, that's, okay. I want to hear from the members if they have any requests for change.
I have none. No, nothing to add.
I have none either, and it looks like from the minutes themselves that April and June were approved at our last meeting. So it would seem that August would be appropriate to approve for this one. So I have no change.
August has not been approved before.
Right.
All right, is there a motion?
So moved.
What I think I call for the motion.
Oh.
Is there a motion?
Yes, there is.
Is there a second?
Second.
Okay.
And I'm sorry, was that Member Anderson?
Yes, Member Anderson was the first. Member Wolf was the second.
Taking public comment on item 2. If you're in the room or in the online community and wish to make public comment on item 2, please raise your hand in the app or press *3. We have no one approaching the podium. We have Member Pilpel's hand raised in the online community.
We'll take public comment.
Can you hear me now?
Yes, Mr. Pilpel.
Yes.
Okay. So it's a bit unusual. I'm sorry I was unable to attend in person, so and I was not able to find a way to participate and vote. So I may be making public comment from time to time during the meeting, but I should be counted as absent. So far, so good. I have not done my usual review of the minutes in detail. I did notice on the bottom of page 1 of this particular set of minutes on item 3, I think it is accurate to say, similar to item 2, the members discussed edits to the meeting minutes, period. I think the reference to sections 67.26 and 67.29-2, I believe, were under item 5 and don't necessarily need to be called out. So my suggestion is just to amend item 3, bottom of page 1, to say the members discussed edits to the meeting minutes, period. I'm not sure that I found anything else of much gravity. If I do see something, I will, what do they say? If you see something, say something. So if I see anything else, I'll say something, but that's all I have on this for now. Thanks.
Thank you.
Do the makers of the motion and the second have want to make any changes or proceed with the motion as it exists?
I would proceed with the motion as it exists.
Taking the vote. Member Anderson.
Aye.
Member Anderson, aye. Member Wolf.
Aye.
Member Wolf, aye. Member Pilpel absent. Chair LaHood.
Aye.
Chair LaHood, aye. 3 ayes, 1 absent. Motion passes.
Okay, please call the next item.
Item number 3, approval of the October 28, 2025 Compliance and Amendments Committee regular meeting minutes.
Okay, members, same thing here. Let's take a moment to look at these meeting minutes. And if you have any changes that you would like to request, please speak up. I'll note that there was some level of detail provided here. This was not intended to be exhaustive, but Ms. Peterson, thank you for including those details, especially regarding the public comment, and anyone who wants to fully understand what was discussed there. I hope they'll go back and listen to the audio from that meeting. Do we have a motion to approve the minutes?
So moved.
Do we have a second?
Second.
Okay, let's open this up for public comment on the acceptance of the October minutes.
Anyone wishing to make public comment on item 3? If you're in the room, please approach the podium. If you're online, please raise your hand in the app or press *3. We have Member Pilpel's hand raised.
Okay.
Mr. Pilpel in this comment?
Mr. Pilpel.
Mr. Pilpel.
Yes.
Yes.
Can you hear me now?
Yes.
Okay. The only thing that immediately I noticed on the bottom of page 2, second line up, instead of public comment with a D, it should probably read public comment prior to 7:21 p.m. That's all I have. Thanks.
Thank you.
Since that was relatively trivial, I'd like to ask, can we just fix the typo?
Agreed.
I
Okay.
agree.
Thank you. Is there any other public comment?
We have no one in the queue.
Okay, please call the vote.
Taking the vote on item 3, Member Wolf.
Aye.
Member Wolf, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Pilpel absent. Chair LaHood.
Aye.
Chair LaHood, aye. 3 ayes, 1 absent. Motion passes. Item 4,
Yes.
public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda. If you wish to make public comment on general public comment and you're in the room, please approach the podium. If you're online, raise your hand in the app or press *3.
Before we start general public comment, I would like to say this. For general public comment, we are going to have a time limit. And for the regular items, but I just want to be clear up front that for the discussion of the Sunshine Ordinance Task Force, we leave that more open-ended unless we suddenly are flooded with a large number of people, at which point I will bring us back to the 3-minute time limit. But just for those who may be here to discuss that in particular, we're not going to be on that particular item unless we get a lot of people. We will be offering many opportunities for public comment. But for general public comment now, we're going to leave it at 3 minutes.
We have no one in the queue.
Okay, please call the next item.
Item number 5, file number 25028. Complaint filed by Anne Marie against the Fine Arts Museums of San Francisco for allegedly violating Administrative Code Sunshine Ordinance, Section 67.5, by failing to hold open meetings, 67.7, by failing to post an agenda, 67.15, by failing to allow public testimony, and 67.16, by failing to record and post minutes of regular and special meetings of the Board and Commission. On May 20, 2025, the Complaint Committee referred the matter to the full task force for consideration of whether there's a violation of the Sunshine Ordinance, Section 67.21, for failing to produce public records. On July 2nd, 2025, the task force continued the matter to the call of the chair. On August 6, 2025, the task force found that the Fine Arts Museums of San Francisco, FAMSF, violated Administrative Code Sunshine Ordinance Section 67.21 by failing and refusing to seek and produce the requested documents and ordered that they do so. In addition, the task force found that the attendance by a majority of the FAMSF trustees at meetings of the Corporation of the Fine Arts Museums of San Francisco implicates Section 67.3 sub B, and thus those are public meetings, and the meetings proffered by petitioner were done in violation of Section 67.5 by failing to hold open and public meetings. Section 67.7 by failing to post an agenda with a meaningful description of each item to be transacted or discussed at the meeting. 67.15 by failing to provide an opportunity for members of the public to directly address a public body on items of interest to the public that are within the policy body's subject matter jurisdiction, and 67.16 by failing to record the minutes for each regular and special meeting of the Board or Commission. The matter was referred to a committee for compliance and follow-up. On September 3rd, 2025, the task force approved the order of determination as amended. On October 15, 2025, the task force continued the matter for compliance to the call of the chair. On November 25, 2025, the Education, Outreach, and Training Committee meeting was canceled due to lack of quorum.
Okay, and point of clarification. So this was supposed to have been heard at EOTC in November, but because that didn't happen, it was sent to us. Is that correct?
That is correct.
Okay. Who do we have here to participate? Do we have both the petitioner and the respondent?
We have both parties. One moment, please.
Okay.
Ms. Mabott, I am promoting you to panelist. You'll be able to raise and lower your hand yourself. Mr. Seifer, I apologize if I've mispronounced your last name, promoting you to panelist. Parties are present.
Okay, what I'd like to do is to give each side 5 minutes to explain where they are. I know that sounds like a lot, but and if you don't need that much, we don't need to take it. But if the petitioner could explain what progress has been made from their perspective since the order of determination was issued, and then we'd like to hear the same from the respondent. So let's give Ms. Peterson a moment to reset her clock since I surprised her with the time.
Ms. Mabott, are you ready for your 5 minutes?
Yes, thank you.
Your time begins now.
Okay, thank you very much, task force members, for the follow-up tonight. I don't think I'll take 5 minutes. If I knew I had 5 minutes, I would have taken 5 minutes, but I know you've all been through this. This has been ongoing behavior for decades, and I appreciate that we've identified some kind of resolution. There's been no progress in terms of compliance with the order of determination that was issued for 25028. I believe I provided you copies already of my original follow-up request. There was no response from anyone at FAMSF or COFAM to the order of determination. So I had to initiate a follow-up, which I did initially on September 8th to Mr. Seifer, which I provided copies to the task force, as well as the response on September 23rd, which was, we do not have any responsive records. I considered that a willful violation of the Sunshine Ordinance, as I explained. So after that, I can't remember the sequence, if that was discussed at a meeting where Mr. Seifer was here. I don't think it was. And then on October 26th, I sent a forward of the same request I had originally sent to Mr. Seifer directly to Director Campbell, since Director Campbell is both an employee of FAMSF and COFAM. And then on October 29th, which I just now, a few minutes ago, forwarded the copy to you, but I received the exact same response. We do not have any responsive records. And it appeared from the email sign-off that even though that was forward was sent to Director Campbell, it was responded to by Mr. Seifer in the exact same fashion. So both on September 23rd and October 29th, they simply responded, we do not have any responsive records. So as I'm sure you are, I'm very frustrated. As I said, I've been studying and investigating and researching this process, I think, as Mr. Seifer liked to call it, or situation, but it's not right. And it needs to stop. And I recommended, as I did in the email, that to consider this a willful violation of the Sunshine Ordinance and to recommend going forward. So if that has to get forwarded ethics or whatever has to be done, not that, and I don't know that that'll do any good at all. So I don't know if it's legal action. I don't know. I didn't research it enough yet to know if there's any chance that the task force can initiate any kind of legal action to compel this now, or if that's left on the public to go through that hassle when they are clearly in violation and are just simply refusing. And not only are they refusing those records, but there's been no change in the behavior. It's just business as is. And then even though I testified at the streamlining task force, the only recommendation appears to be to now submit, to have the mayor approve the appointments. Nothing is essentially changing or is planned to change, despite all the public records on what is going on. So I really appreciate it. I know some task force members, I think, spoke as members of the public to at least the streamlining task force about this. But I would, I guess, implore you, just as task force members who are committed, obviously, as residents, to transparency, to contact the supervisors on your own. I just don't know what to do at this point. I'm just incredibly frustrated, and I want those records, but more importantly, I want this situation to change. And I know that's not within your authority, but as far as the records and compliance with this order of determination, I would just ask to do whatever is in your power to compel compliance. Thank you.
Thank you.
Thank you.
Seifer, are you ready for your 5 minutes?
Sure. Do I, can I turn on video or? Oh,
No.
no. Oh, okay. I won't do that then. Don't worry about it. You can hear me clearly though.
Yes.
Yes, we are audio only.
Uh,
Are you ready?
yes, we can
Your 5
start.
minutes begins now.
My name is Jason Seifer. I'm the Chief Financial and Administrative Officer.
Hold on, please pause. Could you speak closer to your microphone? We're having a hard time hearing you.
Oh, sure. Can you hear me better now?
That's a little bit better. Ms. Peterson, can we do anything to the audio on our end?
Just a moment, please.
Sorry, this usually works just fine, actually.
That I can determine. Not that I can determine.
Okay, we're just going to listen very carefully.
All right. I will raise my voice even more if that's helpful.
Okay, I'm resetting your 5 minutes. One moment.
Okay. Thank you.
Okay, your 5 minutes begins now.
All right. Well, thank you. Thank you for having me here today. I really appreciate that. My name is Jason Seifer. I'm representing the Fine Arts Museums here at the hearing today. In response to, we've obviously met a series of times. As we all know, COFAM, the not-for-profit organization, is a private 501c3. It does not elect any of the FAM SF trustees. We have a city attorney letter on file dated February 5th of 2024 that really details out all of these issues that we're discussing today. It clearly states and it clearly lays out that the FAM-SF and COFAM are separate entities. FAM-SF is obviously subject to the Public Records Act, which we respond to accordingly. However, COFAM is not a public entity and therefore not subject to the Public Records Act. I'd also like to add that, at least at the FAM, we refer to the FAM Commission. The FAM Commission, the board elects all of the FAM-SF trustees at the public meeting as well. So with the request that Anne Marie has put forward, that is why we responded that based upon these facts of the case as laid out by the city attorney, that we don't have any responsive records in this particular situation. And that's actually all I have.
Okay, thank you.
Thank you.
Thank you.
Members, do we have questions for the petitioner or the respondent?
Just have a general clarification question.
Member Wolf, yes, please go ahead.
I've read the order of determination several times, and I'm not sure what we're here to ask them to comply with. Are we asking them to comply with the order to hold their meetings appropriately moving forward? And have they done that since the order of determination was made? Or to produce outstanding records?
Member Wolf, I had a similar thought, and my reading of this was that we were looking for the production of records, since unless the petitioner tells us that she tried to attend a meeting and was met with the same obstacles, if a meeting has not happened where things could have been done differently, there's not much for us to do about that. But as she reported, she says that she has still not received the records that she requested. So Ms. Mabott says she has not received the records. Mr. Seifer says we don't think we need to produce these records, or we don't have responsive records because the entity that she's asking those records from, he says, is not covered by the Sunshine Ordinance. I think the task force disagrees because of the overlap of members of these two entities. Are you looking at things the same way, or do you have a question for the petitioner?
No, that's fine. I mean, it's just that from what I was reading, it didn't seem like it included. COFAM wasn't necessarily named in the order of determination.
Right. So
So it's just FAMSF, which is the, the city's commission or body.
So do you have a specific question for Mr. Seifer?
Well, yeah, for Mr. Yes, for the respondent, what records are you stating that are unresponsive?
So from COFAM, as it is a separate 501c not-for-profit organization.
I understand that. I'm going to interrupt. Wait a second. I'm going to interrupt you for a second.
Yeah, of course.
This is not about COFAM. This is about the Fine Arts Museum of San Francisco.
That's correct. But Anne Marie's requests are for COFAM records, though, not for FAM Commission records. FAM Commission records we are responsive to, as one would expect. It's the COFAM records that Anne Marie is attempting to obtain.
Well, isn't that what we're here for today, is the Fine Arts Museums? No, not COFAM, for Fine Arts Museums of San Francisco. Aren't we here for those records?
We've been responsive to those requests.
Okay, then let me ask Anne Marie, are those the records that you're referring to?
This whole process decided that under the constitution of those two boards and the information they discuss, that COFAM meetings are FAM-SF meetings. So we're just getting into semantics. Those were the trustees sitting on the FAM-SF trustees and COFAM trustees who attended these meetings, the records of which I've requested. You've determined that those meetings were Fine Arts Museum meetings. Those are the records that I want. So you can say, Mr. Sievert, call them COFAM, but this whole process is determined that they are not COFAM, they are also FAM-SF. So to the extent they can both exist, which they can, given the definition and the language of the Sunshine Ordinance, these are FAM-SF records. And I have placed this request for compliance with individuals who are both FAM-SF and COFAM employees, and who, I don't have all the information sitting in front of me, but Director Campbell, I believe, sits on the board.
Okay.
And if he doesn't
Thank
sit
you for
on
the
the board,
thank you for
absolutely has access
thank you.
to the records.
Thank you for the clarification.
Yeah.
I appreciate that. So I'm going to redirect my focus back on the committee members. Is that our understanding here?
That is my understanding. And given that we haven't had any movement on this, I think we need to send this back to the full task force, because it doesn't sound like, and I mean, I don't think there's anything else for us to do except to report back that nothing has changed.
Okay. All right. I'm up for that.
Yeah. Remember, we're having a hard time hearing you as well. I don't know if it might be the system rather than what's happening on the other
It sounds like it's a system, because I usually don't have any problems.
Yeah.
Yeah, I can hear you.
So, or it might be because I'm sitting under the HVAC unit, which is blasting at me.
Yeah, I don't know that there's anything we can compel FAM or FAM-SF or COFAM to do at this point. Mr. Seifert is saying that all the documents from FAM-SF have been submitted. But if they're both sitting at the same meeting and they're operating on two different levels, then
This is the circle we keep walking around.
circle,
Yeah.
we keep walking around, because how do we get around that? If a person whose name is listed as a member of FAM-SF is in a committee meeting dealing with things that do with FAM-SF, then it would seem that any discussion that they have should be public and should be produced. Now, if at the meetings, and I'm not aware of this, Mr. Seifert, you could explain it to me. At the meetings, do they say, okay, now I'm speaking in my capacity as FAM SF? And then is there a break? And then it's like, okay, I'm speaking in my capacity as co-fam. If the same people are on both.
I think here's the challenge. If we were talking about members of one organization who also happened to be on a board for another organization, and the work they didn't have anything to do with each other, I could see them saying this was a different meeting. This is our meeting where we talk about, the kids' baseball leagues, and this is the meeting where we talk about, protecting animals. And these things don't have anything to do with each other. But since the subject matter of both of these entities is identical, how can they be separated?
Yeah.
If I can make just a couple of comments.
Sure. I'm going to ask you, Mr. Seaver, given that the subject matter that both of these entities are dealing with is essentially identical, how can you separate the work that's being done by the people who are members of both entities?
Just a couple of things. Actually, the work on the boards is actually quite different. The city commission is only because of the way the city funding works, and we get into this at the city commission itself. The only things that the city funds are related to security services and building maintenance. Those are really the predominant areas that the city provides any funding for. The not-for-profit organizations step in and actually do all of the main work associated with what you think a museum does in terms of curatorial work, exhibitions, education. That's all privately funded across the board. So these really don't overlap because the city funds very specific things that are separate from what the not-for-profit does. And that's how it's always worked for decades, realistically. One other just quick note that it's actually incorrect that the boards completely overlap. It's quite different than that. So it gets far more complicated. And in many cases, when Anne Marie implies that a co-fam meeting is really a meeting of FAM-SF, that's actually not correct. Not only are the subject matters not the same, but actually the composition is not the same, secondarily, and thirdly, you don't have quorum issues either.
I have a quick question.
Member Wolf.
So Mr. Siebert, is COFAM contracted with the city?
We have an MOU in place.
That's right. That's right.
Yeah, and I think it's been in one of the exhibits in the past. It's very, very, very high level, very simple.
Well, high level or not, the question is what is the appropriate relationship to the city that it has? It provides a service to the city directly, for the interest of the public and the city itself. What exactly is its relationship? Has been before us for many, many, many years, and was explained in great detail by the city attorney's office in that document, if you remember. So I guess again, those things could change. Maybe it changed from being an MOU into a contract. I don't know. But I mean, we've had similar issues with like the Friends of the San Francisco Public Library, what their relationship is. And it's been very clear, about what their kind of the rules around that entity is also. So I'll just stop there. I think I'm in favor of moving this back to the full task force, but I think we have some more. We have other folks that have questions.
Yeah, and Mr. Seifer, what you said before about the boards not being identical, that is our understanding as well. And I believe at, I don't remember which meeting, but we were provided with lists that showed that there was there was overlap of membership. But I understand that there are some people who are on one, who attend one set of meetings who are not necessarily involved in the other, but that there was significant overlap. I don't think that we need to spend additional significant time on this. It's not our job to be re-adjudicating this. It was our job to see what progress had been made and if there was anything that we could instruct the parties to do to move that forward if it was moving forward. But seeing as it's not moving at all, I think the only thing we can do, and since Mr. Seifer, do you plan to do anything differently following this meeting that would be responsive to the commissioner's request?
I think the only thing that I would let you know is that we have taken the feedback from this commission to heart and really work to further delineate and clarify between these entities so that going forward, this is not an issue at question at all. We still disagree that we have an issue from the past, but hearing your feedback, we have taken your feedback seriously to make sure that we do not call into question any of the way that we handle board meetings going forward.
And we appreciate that. Thank you. And we appreciate you being here. That's something that we do consider important. So thank you for taking the time to appear. It does sound like we have a disagreement that's not going to be resolved today. So I think probably the best thing to do for all parties is to move this back to the task force and see where we're going to take things from there. Because I don't see any change happening today.
I agree.
I'll make a motion unless you want to take a comment.
Member Wolf, please go ahead.
So I move to return this item back to the Sunshine Task Force, noting that no change has been made with regards to the order of determination.
Do we have a second?
Second.
Okay. Before I open it to public comment, Mr. Seifer, I would like to ask you. You said that you have made changes and there were things that you've made an effort to clarify. Is there anything in particular that you would like to flag for us as we send this back to the task force?
Sure. I think in general, the question about overlap and your viewpoint about overlap being a challenge. We no longer have any overlap issues in our meetings with our nonprofit board and the public board. So we have ensured that we are sort of below quorum levels just to ensure that people can't question how we are meeting and running our various board meetings. Because at the end of the day, we really are working to further the mission of the museums, and that's really our focus. And I also, once again, Anne Marie, I'm happy to meet with you as I've offered in the past, if you'd ever like to talk. Thank you.
Okay, thank you. I appreciate that.
You might want to see that Anne Marie has had her hand up for a while. Wanted to allow her.
You know what? Well, sure. Let's. Because I can't see that. So, Ms. Mabbitt, if you, we'll take a brief comment from you before we continue.
Okay. Yeah, I'll try to be quick. As far as the examples Mr. Seifer was giving as to the change going forward, that's simply to make sure now that they fall below the requirement triggered by the Sunshine Ordinance. So, okay, great. But I don't see that as an improvement in transparency or accountability for the residents of San Francisco. As far as the two bodies handling very different things, I mean, yeah, maybe I would like to talk someday because I completely disagree. The charter does not give the Fine Arts Museum Board of Trustees authority just over funding security guards and whatever other funding city funds provide. They are to conserve and protect the assets of the museum. It is
Okay, Ms. Mabott, thank you. I'm going to, that is an interesting discussion, but I'm going to encourage you to follow up with Mr. Seifer on that because I think that's beyond the scope
Okay,
of
thank
what
you.
we're doing today, but I appreciate your being here and sharing your thoughts. And one last thing, Mr. Seifer, thank you for clarifying how you're handling the meetings going forward. I think the issue with the records from past meetings would be that if the composition of the boards did mean that quorum was met for past meetings, then I think those meetings and records from those meetings would still be covered by the Sunshine Ordinance. So just as a point of clarification there, but thank you for explaining the changes that are happening. I think we, Member Wolf, Member Anderson, are we making any additional changes or should we open this up for public comment? To the motion.
Not unless you have a suggestion.
Nope, I do not.
Okay, then let's move
Okay.
forward.
Ms. Peterson, let's open this up for public comment.
Anyone wishing to make public comment on item 5, please approach the podium or raise your hand in the app or press *3. We have a raised hand by Mr. Popel.
Okay, let's set the timer for 3 minutes, please.
Mr. Popel, are you ready for your 3 minutes?
It's Paul Kniha, actually.
Oh, Mr. Neha, I'm sorry.
Does he want to make comment?
No, it's
Do you wish to make public
should I
comment?
proceed or?
Do you wish to make public comment on item 5? Your hand is
Yes, I do.
raised. Okay. Are you ready for your 3 minutes?
Yes, I am.
Your time begins now.
I think this is a very important matter, and the key question here is whether the members are actually discussing fine arts business should be the determining factor. If they're there for any matter that has to do with fine arts, they should be subject to the Sunshine disclosure because they're being there for sole purpose of representing the city or providing a public service to a city. So as long as they're present there, and as long as they're discussing any public business has to do with the interest of general public, it should be subject to the full disclosure under Sunshine Act. And even if they were talking about other matters, really, if they're really there in any city capacity and representing city's authority, and supposedly this is a part of their duties and part of their salaries, they're getting paid for that, then it should be subject to the disclosure wherever they go, whatever meetings they attend. And that's the end of my comment. Thank you very much.
Thank you.
Thank you.
And now, Mr. Popel.
Can you hear me now?
Are you ready? Yes.
Great. Okay. I'll try to keep it to 3 minutes, and if you can give me a 30-second warning, that would be great. So having followed this for a while, I believe that Anne Marie's request is still unfulfilled as to some of the minutes from meetings of COFAM when there was a sufficient overlap with the FAMSF trustees. And I still believe that to the extent that FAMSF has COFAM records that are responsive to a public records request, that their obligation is to respond to those records requests regardless. Those are records in their possession if they in fact are in their possession. The 2024 memo to the task force was quoted and is a public memo. I think the task force has received some other advice that's not public, and I have no idea what FAMSF or COFAM has been advised by their advice attorneys, whether city attorneys or outside counsel, as to the application here. I think I heard Anne Marie say earlier, and I think to some extent Mr. Seifer also suggested that they could have a meeting of the minds. I think under the current structure, some document that doesn't exist now, I think could be created that clarifies for the public and for all concerned, this is how the current situation is. This is who makes decisions about the collection, which is owned by the city. This is how decisions are made with regard to operations and exhibits and marketing and whatever else. This is how security and building operations are handled. You know, essentially laying out the separation between the two entities, if there is in fact a separation. Is how the finances works. Here's where you go to get this information. Here's how you get that. If you have public records requests, here's how those are handled. Just some document that summarizes what Mr. Seifer was giving a high level.
30 seconds.
Thanks. Was giving a high level explanation about that might yield some better information for Anne Marie and others concerned about the museum operations as they are currently structured. And to the extent that the museum would work with others to develop such a thing, I think that would go a long way toward resolving at least part of the concerns here. And that's all I have to say at this point. Thanks.
Thank you.
Do we have any other public comment?
We have no one in the queue.
Okay, please call the vote.
Calling the vote on item 5. Member Wolf.
Aye.
Member Wolf, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Pilpel absent. Chair LaHood.
Aye.
Chair LaHood, aye. 1 absent, 3 ayes. Motion passes.
Okay, Mr. Seifer, thank you for joining us today. I appreciate you being here. We're going to be sending this back to the full task force, and we'll see what Chair Yankee decides to, how he wants to proceed with this matter.
Thank you. for your
Thank
time.
you.
Item 6, file number 25035. Complaint filed by Paul Kaniha against San Francisco Municipal Transportation Agency for allegedly violating Administrative Code Sunshine Ordinance Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. On July 22nd, 2025, the Education, Outreach, and Training Committee found that the task force has jurisdiction, that the requested records are public, and referred the matter to the full task force for hearing and to warn the San Francisco Municipal Transportation Agency that not sending an authorized representative to the full hearing would be a violation of Administrative Code Sunshine Ordinance, Section 67.21, sub E. On August 6, 2025, the task force found that the San Francisco Municipal Transportation Agency, SFMTA, violated Administrative Code Sunshine Ordinance Section 67.21 sub B by failing to comply with a request for inspection or a copy of a public record within 10 days following receipt of such request, and requested that the SFMTA provide the fiscal year 2024 through 2025 cost recovery calculation, the fiscal year 2024-2025 costs to date that are color curve specific, even if it does not cover costs, and performance metrics for fiscal year 2024-2025 for the color curve program in whatever form they exist, likely as an extract, and referred the matter to a committee for compliance and follow-up. On September 3rd, 2025, the task force approved the order of determination as amended. On November 25, 2025, the Education Outreach and Training Committee meeting was canceled due to a lack of a quorum. Chair LaHood, we did receive a request for continuance from respondent on December 23rd. One moment, please, while I pull up the response from petitioner. We responded that we received a response from petitioner, Mr. Kaniha, who did not agree to the continuance. This office notified him that the item would remain on the agenda and that per the Sunshine Ordinance Task Force complaint procedures, the committee could vote on whether to continue by a majority of those present.
Okay.
We,
So the petitioner is here, the respondent is not here. Is that correct?
that is correct. Respondent was not able to attend, and that's why they requested the continuance.
Okay.
One moment, please. Let me promote Mr. Kaniha to panelist.
Okay.
Mr. Kaniha, confirming that I am speaking to you.
Yes,
One moment, please, promoting you to panelist.
thank you very much.
Okay. As with the last case, Mr. Kniha, I'll give you up to 5 minutes, but please just use as much of that time as you need to give us any updates about, have you received any of the records that were supposed to be delivered to you following our order of determination? And if you could give us any other updates you have about your communications regarding this particular complaint with SFMTA.
Mr. Kaniha,
yes.
are you ready for your 5 minutes?
Yes, I am.
Your time begins now.
Thank you very much. I appreciate everybody's time. I will try to be as brief as I can. The matter is simple financial records for the city that they not only should have available, but they used to publish. And then they made a decision to switch, go away from a cost recovery and start taking public funds. My request was what justified that action and who approved it, and why all of a sudden the taxpayers have to pay now for the program that they never had to pay for. And at the same time, the request, the records that I requested were the performance metrics that were supposed to justify the increased costs. SFMTA claims that they went away from cost recovery program because of the increased cost, and they were claiming that they were no longer able to charge the fees that were set in the past. And my request was to justify it, show it. If this was really the reason, if you collected that information, this data should be available, and it would be presented to anybody who is supposed to make the determination whether it's a valid request, and whether the circumstances are such that they would justify spending taxpayers' money on something that it hasn't been spent on. And if such decision of such magnitude was made, there must be public records. And the SFMTA provided very scattered records. Most of them were projections. There was only one record that actually showed the calculation of the costs of the program, and we already in 2025. So at the end of the 2025, so those records, they should not be no longer projections; they should be actual records. And ever since we had the meeting where the determination was made that the SFMTA will provide the performance metrics and the financial data for the fiscal years that we discussed, which I have to stress, I really appreciate that we are getting to that level, but there shouldn't be any need for piecemealing. The record was for a specific justification of a determination of how taxpayers' funds are going to be spent. The request was for all of that and for performance metrics, not just some scattered financial information, even though like I said, I really appreciate the efforts of the commission to narrow it down to those specific things to at least start getting some information, start needling that thread. But I appreciate that, but the SFMTA has not provided me with any documents that I request. And I'm done. Thank you very much.
Thank you.
Thank you. Members, what do we do? It seems like we're not very effective with compliance if we can't get the respondents to show up here. Is it, although in some ways it's similar to the last case where the respondent said, we're not going to do anything differently. In this case, they haven't done anything differently, but they haven't appeared to say, we're not going to do things differently. So I don't know whether it's worth it for us to send back to the full task force, or if we do need to hear from them at a hearing, whether it's ours or whichever committee could, take it next. Member Anderson, go ahead.
Yeah, what I was going to say is, although it was late in the day, they did request a continuance.
Yes.
So do we want to put this over for our next compliance?
Yeah, the thing is, our next meeting won't be for 2 months. So I feel like if we do that, it gets stuck with us. Whereas, Ms. Peterson, could we hand it back to Chair Yankee to schedule at whichever meeting he sees fit?
I will defer to Mr. Young, but you may refer the matter to a committee.
Which committee is meeting next?
The next committee meeting is at the complaint committee.
And when will that be?
One moment, please. The next meeting of the complaint committee is the third Tuesday of January, January 20th.
It seems to me that that's probably the best option rather than hanging on to this for 2 months.
Yes, I would tend to agree. So we should push this to our next task force meeting so Chair Yankee can assign it.
I guess Ms. Peterson is saying we as the committee can direct it to another committee. We don't have to.
We don't have to wait.
Yes, and I do want to note that we have a heavy docket with pending
Right, so
cases
it
waiting
won't-
their first hearing.
Right, so it won't be taken up at the full task force hearing. You're saying that the full task force has a heavy docket, or that the
The
complaint
complaint
committee
committee,
has a heavy docket?
yes, with the recognition that any committee may hear a matter for jurisdiction and merit.
Would it be better to send it back to the full task force?
Well, I think at this point, since the referral to committee is really in the chair's domain,
Mm-hmm.
I think we need to send it back to Chair Yankee and let him, mull it over where it needs to go next.
Yeah, I mean, the one thing is if we hand it back to him, even though it's already Tuesday, and I think it's unlikely that it would end up at the full task force hearing, at least if we put it back in his hands, he would have that option, say if participants on another item happen to drop out, he might say, well, let's take care of this now rather than sending it to complaint.
Well, I give him a heads up because he wants to make a decision on that before the task force meeting.
Right. He would need to make, because of holidays, he would need to make that decision tomorrow.
Oh, I see.
Yeah.
Well, there's always tomorrow.
There's always tomorrow. Okay, I'm going to make a motion that we send this item to Chair Yankee for his consideration, whether to take it up with the full task force or to assign it to the next committee that is meeting, which is the complaint committee, noting that the respondent was not in attendance, had requested a continuance, that the petitioner did not want to grant. But as a result, we don't have enough information to do anything with other than to continue this matter.
Second.
I need to summarize.
Okay.
Is this a referral of the matter to the full task force for consideration with no recommendation? Noting that respondent had requested a continuance and that petitioner had not agreed to the request.
This is referring to the chair of the task force.
We're sending it back.
Yes.
So referring the matter to the chair and not the full task force.
Correct. For
Reassign.
reassignment at his discretion.
Public comment?
Yes, please.
Taking public comment on item 6. If you are in the room, please approach the podium. And if you are online, please raise your hand in the app or press *3. We have Mr. Pilpel. 3 minutes.
Mhm.
Can you hear
Hello,
me now?
Mr. Pilpel, are you ready for your 3 minutes?
Yes. Can you hear me now?
Yes, your time begins now.
Great. Pointing to page 106 of the packet, there was an email from Pat to complainant or petitioner and respondent in November, checking about the status of records produced, referring to the text of the order being very specific. I don't believe I've seen an exchange of records. Lastly, as a reminder, see the communication regarding attendance at agendized task force meetings. It doesn't appear from the packet that there was a response to that. Had there been a response from MTA either in November or in December, we would have the information that we're seeking. So we don't know if, we heard from Mr. Kaniha that he's gotten nothing further, but we don't know from MTA if they intend to provide anything further. They were reminded about participation and said that there was no one available at MTA, an agency with 5,000-6,000 employees who could attend today, and they did not provide an update as to the status in response to Pat's very direct and very reasonable request from over a month ago. So I support sending this back to Chair Yankee. I don't believe that this will be calendared for next week's full task force because neither party would have sufficient time, the 5 days, to provide material for inclusion in the packet. So I think it would either get sent to EOT at the end of January or to the full task force in February, perhaps similar to the fine arts item from the previous item. But it does seem to me like, at a minimum, regardless of staffing, that MTA could have and should have sent someone tonight, someone authorized, hopefully someone knowledgeable, and could have and should have responded in writing to Pat's very reasonable request for follow-up and status, again, from over a month ago. That's the information that this task force and the committee asked for, and that's the
30
information
seconds.
that is not there right now. Thanks.
Thank you. Do we have any other public comment?
We have no one in the queue.
Okay, let's call the vote.
Taking the vote on item 6. Chair LaHood.
Aye.
Chair LaHood, aye. Member Wolf.
Aye.
Member Wolf, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Pilpel, absent. 3 ayes, 1 absent. Motion passes. Item 7.
Okay, thank you.
Hearing. Review of the Administrative Code, Sunshine Ordinance, Section 67, and possible amendments to recommend to the full task force. The agenda included the statement that committee members should review the 2 attached documents which refer to high-level recommendations for suggested amendments to the ordinance. The first document incorporates edits based on the last 2 meetings with the full task force, and the second document includes raw notes taken at the November and December task force meetings. And for further details, we did refer individuals to the audio recordings of those meetings.
Okay, here we are again. Here's what I would like to do before we jump into this, and I hope.
One
sorry.
last statement, I'm
Yes.
sorry. The agenda also mentions that the goal of this committee is to continue refining the recommendations in order to advance them to the full task force for consideration.
Thank you. I appreciate that. And I hope what I wrote and sent and why it looks the way it does is clear. What I'm trying to do with the document is condense and condense and condense, because at the end of the day, if we deliver something that is lengthy and hard to understand, I think it's not going to be well received. So even though some of what we're writing may not include all of the details that individuals think are needed, we absolutely can discuss that and talk about how to refine it more. But ultimately, we are trying to create something that is very succinct and concise and includes things that we either all agree on or mostly agree on, which might mean setting aside some things where we really don't have consensus or where there are just a wide range of opinions. I would love to give an opportunity for each member of the task force just to give some high-level thoughts on this. I also did include my raw notes on the second document, and I hope you all see that even though with the PDF, some of the comments get cut off, they actually are footnoted and run to the end so you can see everything that is there. I hope that's clear. I know delivering things in PDFs like this is not ideal for these scenarios, but it's these are the limitations that we have with our agendas. But on the whole, I think it gives you the information that you would need. I'd love to hear from each of the members who are in attendance today, and then open up for public comment. I know we do have a member of the public in attendance in the audience, and would like to hear about his thoughts as well. Member Anderson, do you have any kickoff thoughts that you would like to share with us, or just general comments based on the recent meetings that we've had or what we're about to walk into next?
Not extensive comments concerning this. I think we have done yeoman's work in going through the ordinance and trying to make those suggestions for changes that would make it more effective for the public to get the information that they need. So I look forward to reviewing each of these with the rest of you and reaching some consensus of where do we go from here.
Thank you. Member Wolf, do you have anything you'd like to kick off with?
Yeah, no, I have similar sentiments. I just want to make sure that in the final product, it'll be the standard strike through, kind of amendments that we're generally used to in the formatting.
We can talk about that. I would say if we want to do that, I think it would also be helpful to have a summary document like this that gives the high level overview and then zero in on which aspects of the ordinance we're talking about. I think the one thing where we talk about doing changes throughout, do you think we should do those changes throughout or leave that as a point that essentially a set of instructions for whoever's going to do that, perhaps on the legal side?
Well, I think I don't think the legal side is going to want to do it.
Okay.
If they have to, I guess they would, but that means they would have to go back and see all of our, go back to the original, which is currently there, and then whatever the final language is, to then insert it, do the strike through and then insert the new language in italics, that kind of thing.
Yeah. Then I'm going to recommend that we still focus, at least today, on the summary and then go back to a clean version of the ordinance as it exists now and do each of these things that we're proposing. And of course, look at the previous version that we've already edited and I think got some degree of consensus on. But since there are so many other edits in that document that we're, I think, maybe deciding to set aside, that we not try to do it off of that, but essentially we're creating a recipe and then we're going to follow the recipe and apply it to the ordinance.
Okay. Sure. As long as we have the exact language that we want to insert or replace.
Yeah, and believe me, I've got many many versions of this sitting on my computer, so I should be able to pull all of the things for the sections that we are now agreeing need to be updated.
Okay, thank you.
Okay, cool. Let's open this up for public comment, and I'm actually going to start in the room. Mr. Goretsky, I know you had a statement that you wanted to read into the record.
Thank you very much.
Is there a time?
I'm not putting a time limit on this because, as I said, we like these to be open discussions. I think we've learned a lot from people who have come to attend these meetings, so we appreciate you being here.
Thank you very much. I'm Joe Dworetsky. I'm a reporter at Bay City News. I cover legal affairs and I do investigative reporting, generally in the form of long-form narrative. As a beat reporter, I rely on the Sunshine Ordinance for a lot of my investigative work. Sometimes it's the only way that you can find collaborative or, underlying source material. And I'm submitting these comments from my perspective of trying to do my job. The most important point I want to make to the task force is that the Sunshine Ordinance has a very broad scope of what public records are, and that's fantastic. But equally important to what the scope of what must be produced to the public is the timeliness of production. And on that, I've had many frustrations, and I wanted to make 3 points, 3 specific things about what these amendments could do that would be very positive for the public, and particularly for reporters like myself who are on deadline trying to do things in a timely way, so that what we write about actually matters when we write it. The first, and I'm going to say this is not true of every department, but I think that the task force must recognize that there are many departments, or several departments at least, where the custodian of records reports to either the public relations or the legislative relations personnel within the department. Those are the people who are responsible for the department's narrative on matters of public concern. And the potential for conflict there is significant. It's not always an easy, friendly process to try to get records which the department thinks are inconvenient for their narrative or are not, that are sensitive or politically damaging. That's a backdrop that just is behind this whole thing and I think has to be kept in mind. That's not the case for many, many requests, but it is there, and it's sometimes there with respect to the very most important things. Something that is not produced timely can either, disappear completely, or it will no longer have, the reporting on it will no longer have real meaning. One strategy that I've seen in the past, in which I've litigated a matter through the through the board of, through the full task force in the past, relates to the rolling production section. It is used by some departments in some circumstances as a justification to avoid the clear deadlines that are in the statute. You have 10 days and then you can have, under certain circumstances, an extension. But a department that produces some documents, you know, on the 10th day or the day of the last day of the extension, and then says that they're still looking for more and will produce them as and when found. There's no, and then they take the position that the deadlines are all no longer relevant, that it's just up to trusting them as to when they produce them and when they find them and when they produce them. I believe that's a serious misreading of the statute, and I've argued that here in the past. But I do have another suggestion for the ordinance. While I do think it should be made clear that there is no carte blanche once you start rolling production, the deadlines still apply. But there are situations, and I think the task force has struggled with this before, where something really can't be done within the original period, even with the additional deadline. And my suggestion there is that the ordinance say that in that, what should be an exceptional situation, the burden then switches to the department to come to the task force and say, there's a reason here why we need an additional period of time to respond. They would do it by the department head signing, you know, an affidavit or a filing that says, here are the reasons that, first of all, here's what we've been able to produce, and here's the time frame we did it in, and we've done everything we can. Here's what we can't produce, and here's the reason why we can't do it. Here's when we'll be able to produce it, and that we're telling you that if you give us that extension, we'll make it by that time. That would accomplish two things. One is it would be a vehicle for both the requester and the department to get together to mediate or to, you know, to exchange, you know, proposed timelines. And that's always the best way to get something resolved. But it would give an equal, weight to the positions of both parties, so that if the department has a record of recalcitrance, or if there is something that's of exceptional importance, then the other party would get the affidavit that was submitted and could make their own response. I think something like that, by explicitly changing the burden, would make a big difference in practice. And then when the commission, when the task force or its designee, and I think it would be a designee, would decide that, there could be conditions on it. Yes, you can have this extension, but you're not getting 6 weeks, you're getting 3 weeks. Or you're getting it, but we want to know after 1 week how much you've done, and you give everything that you found along the way. That seems to me a reasonable system and one that would work better than what we currently have. So that's my first suggestion. The second thing relates to the system that on the public website, the portal, when one comes in, and there's an opportunity for a requester of records to, before requesting or making a public records request, they can survey what requests have been made in the past and what documents have been produced with them, and see if what they're looking for is already there. That's a very, very useful tool. And you think about it again, my issue is timeliness. If I'm on a story and I've got a short deadline, if I do a public records request, I know I'm going to have likely, if it's not an immediate disclosure, I'm going to have 10 days, and it could be an extension at the end of that, so it's 20 days. But if it's already been answered, if the documents that I'm looking for have already been provided and they're already there on the website, it not only saves me the 20 days and makes the reporting fresher and more relevant, but it allows the department not to have to redo something that they've already done before. There's no issue about privacy because when they disclosed something before, they redacted anything that had to be redacted. It's all there and it's all done. But what I learned from the investigation that we did at Bay City News was that despite the fact that this portal is there and it offers this very productive service for the public, many departments don't allow their documents, their public records requests to be included in it. And they have that right unilaterally. It's not There doesn't appear to be any citywide standards that say when you can do that. It's just something that each department on their own willy-nilly can do. And some departments never let their public records requests that have given to one person be available on that site. And it just seems to me inefficient, unproductive, and it encourages hiding things. And I don't think the department should let that happen. I think that should be the default should be that when a public records request is responded to and documents are produced, that they go onto this portal and they just are visible. It's not like it's any extra work. It's just one box, the visible box or the non-visible box. So it's all there. It just needs to be, the understanding that that's what's done, unless there's some, important reason why it shouldn't be done. But again, it's not a privacy issue because everything has already been redacted. The other thing we learned in our investigation that was amazing to me was that on May 1st, there was a purge of 50,000 records requests that were on this public system, many of which were visible and could have been searched by the public. And with them, what we estimate to be almost a million documents that had been what had been produced. That purge was made, as far as I can tell, without any notice to the public, without any approval by anybody within the city leadership, without the knowledge or the approval of the Sunshine Ordinance Task Force. It was done by the Department of Technology working with the various departments. And while I understand that you do have to keep systems secure and nobody wants to pay for extra storage, it seems to me very inconsistent with the way that the Sunshine Ordinance came into place to allow the departments that put their records out there to be the only ones that decide about a purge of public records. These could be, and because they're purged, we don't know what was there, but they could be, and our reporting shows that in some cases they did include things that were very relevant to important issues that were in the public. And so I think that there should be a procedure before there's a purge of records from the system, that there's an approval process, that it go to the City Technology Committee, that it goes to the task force beforehand, so that you don't have what they told me when I interviewed them was they didn't need approval from anybody because this was a system configuration. It wasn't the destruction of records. And they're correct that the original records are probably still in the departments where they were. But the public aspect, the part that's easy and convenient and economical for people to find things, has been purged. And I just think that's bad public policy and doesn't do the citizens of San Francisco or those of us who try to report the news in a fair and timely way any good. I've written articles about each of these 3 points. I've cited them here, and I think they've been previously provided to the committee. And so I just wanted to come in and say, I'd really urge you to give careful consideration to these points. Thank you very much.
Thank you.
Thank you. We appreciate you coming here with your comments. Are you able to stick around for a little bit if we have some questions? But I wanted to let other members of the public.
Sure.
Okay,
Sure.
Great. Thank you. Who else do we have who wishes to make public comment?
We have no one in the queue.
Okay. Mr. Dworetsky, thank you for coming today. That was, you have sent us comments before, and I know we've talked. I think a lot of the suggestions you make and things you bring up are great points, especially in terms of rolling response, which is challenging both ways, because on the one hand, we want to make sure that records are delivered on a rolling basis if it's a voluminous request, and that they're not saying, well, we'll wait until we're done and then we'll give you everything. But your description of a scenario where it could be used in a detrimental way is also a really good point, and I think something that we need to take into consideration. Members, do you have any specific questions? Member Anderson or Member Wolf?
Member Anderson, I don't, but I like the point you took about the rolling request.
Yeah.
And maybe we need to think about something to do to say, okay, you've got this much time. And if you need more, you have to come back and ask for it.
Right,
It's not
right.
something that just goes on for 15 years and.
Right, and it would have to be either a clear agreement in writing between the parties and where the petitioner says, yes, I agree to that. Thank you for delivering, things every other Tuesday. I accept that. Or that it needs to come to the task force and there needs to be some sort of sign off on it.
Correct.
Yeah. And member Wolf, I know I wanted to offer if you have any questions, but you've also said a lot about the records retention and, what the city's capacity might be or could be and whether, these kinds of previous records requests could just be maintained in perpetuity so that A, departments wouldn't have to reproduce them, and B, it would just make it much easier for members of the public to see if what they are asking for has already been generated.
Exactly. I mean, there is no need for Iron Mountain warehouses to store, hard copy anymore, since almost everything is electronic now, with almost an endless supply of storage space. I think the whole retention of records needs to be revisited, because it's the history of the business of the city, and to purge it means you lose that history, especially if there's evidence that's needed, that can't be found anywhere else because it's original information. That's it.
Okay.
One more thing.
Yes.
Sorry, one more thing. The whole idea of them asking for an extension. So I heard Mr. Drewski say that you get the 10 days and then they ask for an extension of another 10 days. There is no additional extension. That only exists in the CPRA, and in the Sunshine Ordinance, we've more or less removed that extra amount of time. Their time is supposed to be within the 10-day turnaround, and not to take advantage of it. If they can't produce it to you effectively, like within a day or two, then they have the rest of the time to provide it on a rolling basis. And I think that is prudent. Now, whether or not that's the reality of the city or not, and how they operate, and if they have the ability to retrieve and get those records in that level of timeliness, I think still needs to be researched. But nonetheless, I think, when the public needs a document for a particular reason, and the public needs it in a timely manner, the city shouldn't drag its heels by making you wait, months, weeks, months, and years for those documents on a quote unquote rolling basis. So I think there needs to be some tightening of the reins there, I think. That's it.
Thank you. Thank you. Well, I guess we didn't have more specific questions, but we appreciate you coming here and I think adding some detail and nuance to things that we were considering, just based on your experience of responses to your own records requests. So that's actually really helpful to us.
Thank you. And I'm glad to offer my encouragement to bring this process all the way through to the end, because this is really important stuff for the production of, timely news about the city's financial condition and all the other important things in the city.
Yeah, we're going to do our best. I mean, something that's come up recently is the question of whether, we're trying to coalesce these ideas around some very specific recommendations. And the question is, are we going to be able to get the city to do anything about that? Are we going to be able to get this on the ballot for voters to consider or approve? Given everything else that's happening, we don't know how long it's going to take, but we think let's do the work now so that we are ready ready to bring this forward as soon as we can. So I don't know how long it's going to take, but we think it's worth doing the work now and worth going through this process. So
Carry on.
thank you.
Thank you very much. Good night.
And let's check. Do we have anyone else wanting to make public comment at this point, or should we dive into our discussion of the summary document?
Anyone wishing to make public comment in the online community, raise your hand in the app or press *3. We have no one in the queue.
Okay. Members, if we look at the first version of the document, which was my attempted sort of cleanup, now I have to find this version in because I opened it up in Word again. So the one that says this document incorporates some recommendations suggested. And I would say it incorporates more on the top because those were the ones where we had more sort of detailed explanation. Why don't we review the enforcement section again and tell me if you think, and I know this might require sort of looking back and forth between the original and this one. In this summary, have I captured enough? Is there anything you would trim or condense more or word differently? Tell me what you think of what we've got in this section. And in some ways, even I look at this and, when we say 6735D is particularly confusing, maybe that doesn't, it is confusing, but maybe this won't actually make enough sense until we do what Member Wolf has said, which is then look at the line edits on that section. But in terms of summary, does this capture the things that we intend to change?
From what I read so far,
Mm-hmm.
it does. Let's see if I made any notations. No, I haven't. Yeah, I have no further notations.
Okay. Member Anderson?
I agree. It
Okay.
covers all the things we discussed. And you're right, that first sentence, 6735B, is particularly confusing. Doesn't really say anything unless that's 6735.
Yeah. Okay, if we move on to well, actually, I'll ask do we have anyone online who wants to make public comment on this first enforcement section before we move on to looking at the supervisor of record section?
Anyone wishing to make public comment, please raise your hand in the app or press *3. We have no one in the queue.
Okay. Actually, we can look at both of these, supervisor of records and authorized representative. Again, this might be a situation where I think we're all on the same page. We need, we talked about this. I actually, at the full task force meeting, because we had asked our DCA, were they supposed to, had we asked them to ask their department? No, we actually asked we asked someone who, we asked for a response from the city attorney's office. And now I'm thinking it was the person who actually delivered their annual report. And we had asked, I don't know if we need to have a formal conversation to find out what they do and don't want to be doing. And if they would rather be taken out, or if they have a different idea for how to modify their role so as not to present it that we just want to make sure that members of the public don't think that they're going to do something that they're not actually going to do.
I have a question.
Member Wolf.
Has anybody seen the anything from the streamlining task force about the city attorney's office? If they were listed at all? Because the whole result of the streamlining task force is there's going to be a charter amendment to rewrite some major portions of the charter that's going to be on the ballot.
Right.
So
this also could throw a wrench in everything we're doing. Yes.
right. So the question is if there it states that first of all, I don't know if it states in the charter that the city attorney is the supervisor of records. I don't know if that's where it begins, and if it doesn't begin there, then it begins here in the ordinance. So the question is whether the ordinance is going to be put on the ballot or not by somebody to make amendments here and there, unlike what we're doing, which is more of a full revision.
Okay, so I think I understand what you're saying. You want to know, is the commission streamlining task force proposing changes to the responsibility of the city attorney's office? Is that what you're asking?
Yeah, that's the first question.
Okay.
Second question is there will be, because of the results of the streamlined task force, certain things would need to be changed in the charter. So there would have to be a charter amendment anyway. And if there is, then the city attorney can say, please include removing us from the role of supervisor of records. That's my question, is whether the role of supervisor records exists in writing in the charter or not.
Beyond the Sunshine Ordinance, is that what you're asking?
Well, it comes before the Sunshine Ordinance. First it's the charter, then it's the ordinance. If it doesn't exist in the charter and it only exists in the ordinance, then that would need to go to the voters anyway, but only as an ordinance, not a charter amendment.
Okay. Should we do a quick search? Let's do a quick search.
I'm doing a quick search.
Okay.
I've not dived into it that deep. I've always felt that the role of supervisor of records is very clear. It would be in perpetuity. To me, it was semantics, that it was just repetitive, that it's in the ordinance, but maybe it's not. I don't know.
You mean not in the charter at all about supervisor of records?
I don't know. I never took the opportunity to check. I made an assumption that, they were the de facto supervisor of records, to make decisions ultimately about what would be, public record and what wouldn't be a public record. I mean, if you read 6721 as a sequence from, from the, first section from the first paragraph to the last paragraph, then the supervisor of records is the first one to make the decision if a record is public or not. And only then, if they say it's not and the petitioner doesn't agree, then they would be able to petition for hearing before the task force. That's the way I read the language. So if they are the supervisor of records, then, you know, their role is to hear from the public complaints first. And then the task force comes in second, supposedly. But if they don't want to assume the role of supervisor records, then they're going to remove themselves from that process completely, so that the complete onus is on the Sunshine Task Force.
I think this only comes through the Sunshine Ordinance. I don't think it's part of the
charter.
Yeah, I mean, on the city attorney's own website,
I wouldn't go by
says-
that.
the San Francisco Sunshine Ordinance designates the city attorney as a supervisor of records for purposes of considering petitions by requesters to determine whether records withheld by San Francisco city agencies, employees, or officials in response to Sunshine requests are public.
I would just double check. I can't really trust who puts what on a website,
Right.
you know, versus what is in the actual record, the official record. So if the supervisor records designation is made in the charter, then that would require a charter amendment to remove it. If it doesn't, then it requires a simple, you know, ordinance amendment before the voters, which is less of a threshold if signature gathering was needed or a number of supervisors required to support it, to put it on the ballot. Or the mayor can just put it on the ballot himself. I think. Well, the ordinance, I think he can. I don't know if he can with this one, though, with the Sunshine Ordinance, because the mayor's excluded from all oversight over the Sunshine Ordinance in spirit anyway. So I don't know what the kind of the ramifications of that is. That may be an interpretation, it may be precedent, who knows? I don't know. But the question then becomes, is there a need for it
Right.
in general? Do we want it? Do we, as the Sunshine Task Force, feel the need for a supervisor of records?
Well, I guess sorry, Ms. Peterson. Yes.
Through the chair. Yeah. Member Wolf, are you referring to Article 6 in the charter on the designation of elective officers?
Not
Section 6.
necessarily. It's not about the actual person who is sitting in that role, more about, I think, what the office operation is. So it would be kind of in the area where the it describes the city attorney's office and its overall scope of work. Like the city attorney shall be the official legal counsel for the city and county of San Francisco. It shall do this, you know, and the whole list of things that come under its jurisdiction. Does supervisor records fall in that?
It is not spelled out in fact, there's nothing about records in section 6.
What about compliance? Because they have a whole
Compliance with
compliance
what?
unit. Compliance with city law.
Nope.
And they have a whole
At
compliance.
least not with the word compliance.
Okay, because you know that is who we get our legal counsel from, is the compliance unit. We don't get our legal counsel is solely from the compliance unit because it's fairly, kind of inert. They just focus on what's written in the law, whether it's, somebody takes an action, is that in compliance or not with the law the way it's written, much in the way what we do. So that's my overall thinking. That's how I think about this.
Well, here, there's actually a very, as I'm scanning this,
I mean, there is a whole area around, city attorney makes opinions, and the opinion of city attorney is considered with the greatest weight of it being law until it's challenged or overturned or overruled by the judiciary. There's probably some language that reflects that. That's why I really don't see opinions of the city attorney that much, because no city attorney likes their opinions to be overturned. They just would rather the court make the decision. It's too embarrassing.
I'm reading this whole section about if there's a conflict of interest, then a retired judge gets to determine whether there's an actual conflict of interest and outside counsel should be retained.
Right. Yeah, we've been through that one. I tried to invoke that when trying to find a different attorney from a different department that is not part of the city attorney's office.
How did that?
And they all said, well, the conflict of interest for us is we all have to follow the Sunshine Ordinance. So I'm like, that's not the point. Ethical firewall, dude.
Yeah, okay, just to answer the initial question, it appears that there is nothing in the charter that describes the role of supervisor of records, and there's nothing that specifies compliance.
Okay. Well, then it sounds like it was a pure invention of the Sunshine Ordinance.
Yeah.
And then, they could have it readily removed. But if they do that, if they want it removed from there, they would have to put it on the ballot, and that would give us the window for our revisions.
Oh, you're saying if they put anything on the ballot regarding the Sunshine Ordinance, then you think that will give us an opportunity to get everything we're talking about in?
Well, if the supervisors agree with our changes, with our amendments, then they will, include it with the changes that they seek to be doing. Now they could say no, go collect signatures and do it yourself. They could do that.
Okay, just to move forward with this, does it sound like, should I, in writing, ask our DCAs should I ask them to find out whether their own department wants to retain the role of supervisor of records?
I
Or
think it's
should I contact the city attorney's office and say, do you want to retain this role?
I think it's inappropriate to have our legal counsel do it because of the ethical firewall.
Okay.
I think the task force should write a letter, asking the city attorney himself, because that's where the letter originally came from.
Okay, so here's what I should do. I'm going to write an email to Chair Yankee and say, will you send a letter to the city attorney asking whether their department wants to retain this role? And if not, do they mind if we suggest an amendment that would remove that role?
Sure. And you might want to include that is if they've already sought to have it removed,
Okay,
who are they talking to?
yep.
So then we can talk to them.
Mhm.
I mean, any way that we can get our foot in the door, you know, we've talked a little bit about the, the makeup of this board of supervisors a little bit, and whether they would be open to our visions or not. Any opportunity to start networking is a bonus.
Okay. Any other thoughts on this, or should we continue on?
I would say continue on.
Okay, let me just add a note to myself here. Okay, authorized representative. Defining the role of an authorized representative. I think this is pretty self-explanatory, and I think we almost have the language here that should be written in, maybe with a little bit of cleanup. Any other thoughts or details that you would want to add to the idea of what an authorized representative is?
I think the language appears pretty clear
Mhm.
and easily understood.
Member Wolf, any other thoughts on authorized representative?
Well, I'm just reflecting back on the multitude of experiences around the people that show up before us as authorized representatives and how unknowledgeable they are and unfamiliar they are with the details of the complaint. And I'm just wondering if there's any kind of assertion we can include to show that, coming unprepared or not familiar will result like in a violation or something like that.
Well, I don't know if we want to do anything like that here, because the person who's coming is someone who has been told they're to appear before the Sunshine Task Force. So it wouldn't fall so much on the person who appears, who hopefully is knowledgeable, but sometimes is not. But is there, I think we had mentioned something along the lines of writing to the department head saying that, we would request that you send us someone knowledgeable, and you haven't done it yet.
Mhm.
But still, we don't have muscle. How do we get the muscle to get them to pay attention?
Well, that's why I say put in some assertion into the language that this is crucial. You can't just assign somebody just to show up, a body, a human just to show up that doesn't have any knowledge of the case. We've
I
had
was
those.
saying ultimate responsibility lies with the department head. And so I think we just need to state what the requirements are.
Yeah.
And the implication is if you don't follow the guidelines,
Mhm.
that is a violation.
Yeah.
So we don't need to say again and again, if you don't do this, this is a violation. Because that's it just is.
I think that's where sometimes the problem is that we rely too much on implication and don't actually say what we want or what we mean.
So you want to say responsibility lies with department heads and failure to send authorized representative will constitute a violation?
Yeah, something like that, to that effect. Some sort of assertion so it makes it perfectly clear that you just can't send somebody with a, rudimentary kind of knowledge because they scanned a paragraph summary of what the complaint is, that they're going to have all the information, and not waste our time.
Okay.
I just, I think of all the continuations continuances we've done because, they weren't prepared. And if they were ever to go into court unprepared like that, tough boogers.
Okay. Is there anyone there who wants to make public comment either on the supervisor of records or authorized representative discussion?
Yes, Mr. Pilpel has his hand raised.
Okay, Mr. Pilpel.
Can you hear me now?
Yes.
Yes.
Okay.
Again, no timer.
No timer.
Okay. If you'd like me to join the discussion, you could promote me to a panelist. If you want to continue to treat me as a member of the public, then I will not have as early an opportunity to
I
contribute.
think we have to continue to treat you as a member of the public, but as I said, for this portion, we're not holding to the timer, so I will check in regularly.
Okay. All right. That's entirely up to you as to how you want to handle it. As to the supervisor of records, I'm not aware of anything in the charter generally or section 6.102 specifically that addresses the supervisor of records function under the city attorney. I believe that was entirely a creation of Proposition G in 1999, amending 67.21 of the ordinance. So I think the entire concept and all the specifics about supervisor of records and that function is an ordinance, an initiative ordinance created function. So amending that would require a ballot measure or part of a ballot measure to amend that section. I am not aware of any current interest in the city attorney's office or the board of supervisors or elsewhere to eliminate the function in code. They may not, enjoy doing it. And we've asked before what their estimate is of the cost of doing it. And I think we asked that last time when they presented the annual report. But again, I'm not aware of any current movement to change or eliminate it. What we've talked about at the full task force and at this committee before was the idea of not continuing the function, estimating the value of the savings, and redirecting those savings to other costs that might be borne by different functions or changed requirements elsewhere in the ordinance. So as a trade-off, I think our emerging view was that the supervisor of records function, however intended long ago, far away, has not proven so beneficial, and that its costs have exceeded the benefits, and that those savings could be redirected elsewhere. I could say more if there's a request, but otherwise, on the other point about sending a representative, I would try to state it clearly, directly, and succinctly, something like each department head shall send an authorized and knowledgeable representative to task force meetings when requested, and shall respond to either all or reasonable orders and requests from the task force, period. Again, something like that. And the implication is that any failure to do so is a failure on the part of the department head to perform a required act, and is thus a violation of the ordinance with whatever penalties attach and enforcement proceedings and so on. Each sentence or statement in the ordinance that says some actor shall do this thing is presumably a requirement and a directive. And if there's a penalty that attaches, then they suffer that penalty for failure to perform such a required act. So I And I'm not saying that this is any more important or less important than anything else. I'm just saying that if we want to make it a specific requirement, I think that's how we do it. And it doesn't need that many words.
Thank you.
That's my thought.
Okay.
All right.
Let's move on to immediately.
Can
Sorry. Hello.
Can I just say one thing?
Yes, please.
We did get a letter from the city attorney stating that they are not going to fulfill the supervisor of records.
We did get that.
Right.
Yeah.
So I'm just responding to Mr. Pelpel on that because they made it very clear that they were not interested in fulfilling that role anymore. So that's why I made the proposal or assertion that I did based upon that letter. And Mr. Pilpel, if you want to respond to that, go ahead.
Mr.
Mr.
Pilpel
Pilpel?
has his hand raised.
Yes, please go ahead.
Can you hear me
Mr.
now?
Pilpel?
Can you hear me
Yes,
now?
we can hear you.
Yes, yes.
My recollection is whatever communication we received from the city attorney didn't exactly say they weren't going to perform the function. I recall it saying something like they were willing to continue to review and opine. They just felt that they were unable to order production of records from departments because that conflicted with their responsibility, with other responsibilities under the charter or the code of professional whatever. But it wasn't that they were unable or unwilling to do some of the functions of the supervisor of records. And in fact, they have continued to, and we've gotten, several annual reports since. They just are no longer saying that they're in a position to order production of records or order departments to do certain things.
What kind of, I'm just thinking what kind of burden there is in order to do that. I mean, if they're willing to opine, then they could easily write another sentence and opine further and compel, whatever it is that they're opining on.
I agree.
See, I'm going to jump in. It seems to me that they're probably talking to departments and saying, getting consensus on what everyone agrees are public records. And if they don't agree that they're public records, then the department, they're not going to say that something's a public record that the department says is not a public record, or that they're not going to tell the department one thing and then tell the members of the public something else. Right?
I don't know what to tell you. I'm just going by, they sent us a letter saying this, that they don't want to do it, more or less. And that's what I'm responding to. That's all.
I haven't reviewed that communication in a while. Maybe we can pull that out from the wherever it is and put it in the packet for next time.
Sounds like a plan.
Okay. Okay.
I need a restroom break.
Okay, it is 6:48. How about if we come back at 6:55 or 7 o'clock?
Yeah, that's fine. Thank you.
7 o'clock. We'll come back at 7.
Microphones are off. Microphones are on. The committee is back in session at 7:00 PM.
Okay, just so we know that the members are here, could you just take roll quickly again?
Taking the roll following the break. Chair LaHood.
Present.
Chair LaHood, present. Member Wolf.
Present.
Member Wolf, present. Member Pilpel, absent. Member Anderson.
Present.
Member Anderson, present. One absent, three present.
Okay, thank you. Let's continue on to the section on immediate disclosure requests and other public record requests. This one is a little longer, so I'm going to give everyone a few minutes to read through, and then maybe we can take it sort of in chunks.
How long are you expecting to work tonight?
How about no later than 8? And if you tell me you're fading and we need to end sooner than that, we could. But I thought as long as we're together, it would be good to get some work done. I do want, actually, Member Wolf, I wanted to ask if you had had a chance to work on the, you were going to make some suggestions on the disability and accessibility language. I don't know if you have that material together or if that's something that we're going to need to save for next time.
Next time.
Okay. Then I'm going to say no later than 8, and maybe it doesn't even take us that long.
Okay.
Okay.
Yeah, 8.
Okay. Can we jump back in? Okay, as I was reading through these, I decided to make some more subheads. Essentially, everything in here falls under either custodian of a public record, immediate disclosure requests, rolling production, or records retention requirements. Does everyone else read this in the same fashion?
Yes.
Okay. If we think first about the custodian of a public record, better and more specific definition, I think this is something that, again, as Member Wolf suggested, needs to be a strike through and new language. And I think we just, we'll take a try at it and see if we can agree to that. We don't have to do that tonight, but other than that, is there anything else that we need to do related to custodian of a public record?
Nothing I see.
Okay. Member Wolf? Are we still hearing him?
Yeah, I'm here.
Oh,
I'm here.
sorry. Okay, and then as far as immediate disclosure requests, I know this this becomes a little more complicated, but I think this is a situation where we need to be very specific. And then with our first bullet point here, I'm not sure that we've got everyone on the same page with this, but I think the idea of defining what records are subject to it, or just saying it has to be readily available information. So if you know, and then I think this idea of, is this a suggestion or a requirement? You know, the idea of employees on vacation or leave, or part-time employees or board or commissioners using automatic response emails. It does put the burden on those individuals, but maybe if we're okay with that, this could work, unless we think it needs to, you know, because then, you know, it's your responsibility to know if you're in one of these roles that you need to essentially flag your emails so that people know that they can't ask you.
Well, it's based upon our experience.
Yeah.
You know, what was working and what is not working. So that's what we're hoping to make clear here, right?
Yeah. And I think it has improved things for us. So, so maybe learning from that experience and sharing that citywide is a good idea.
Yeah. Should it be a departmental matter as opposed to an individual employee matter? The department should know.
Well,
Or
here's
make
the
it
thing,
plain-
until
make it
they
plain.
provide us with city emails, it
Yeah.
is something that's going to have to be done on an individual level. So in that sense, now that I'm thinking about it, it has to be done this way, unless, you know, I mean, departments are able to do that, I suppose, for their own part-time employees, but, you know, they can't do it for me or you or me.
That's true.
Yeah.
Yeah, I think you know, again, the thing is if we want to go departmental, then we should be following more of the CPRA language.
Uh-huh.
You know, that what makes the ordinance unique is that it puts the onus on the person
Mhm.
as a custodian.
Yeah.
And if we remove that, then it waters this whole section of the ordinance down.
Okay, and then moving on to the clarifying when extensions are allowed. And I think, you know, and Bruce, this came up earlier when you were talking to Mr. Dworetsky and saying, you know, and he had referred to something and you're like, that's in the CPRA, that's not what the Sunshine Ordinance calls for. And yet we know that many departments sort of lean on that CPRA deadline and allowed extension.
You know, we could have something like the respondent can petition the Sunshine Task Force on whether, to allow for extension beyond 10 days.
Oh, that's a good idea.
How about that? And then let the task force make a determination whether it's, reasonable or not.
Would this be in a case when the person requesting the records says, no, I want, because here's the thing, lots of times there's a negotiation and we never hear from anyone because they negotiation in a satisfactory way. So this
Sure.
would be if the petitioner or if the person requesting the records won't agree to an extension, the respondent can petition us for an extension.
Yeah, like where there is a conflict of
Okay.
agreement for an extension of time, then the task force shall make a determination on the reasonableness of the respondent's need for an extension. Something like that.
Okay.
I have a question.
Mm-hmm.
I see what's happening in some departments as far as these rolling out of the requests that are made. Should we find some way to figure out whether they're getting legal advice, the departments are getting legal advice that they can roll it out in this fashion? Or should we have something in the ordinance that says we're the ones, Sunshine Ordinance is where it's determined what is a rollout and what response to IDR is? Because if the departments are getting legal advice that it's okay to roll out information, which I believe I heard in one instance that they were pretty much told, well, you can roll it out in this fashion.
Right.
Then we're working at cross purposes. So how do we make it clear that under the Sunshine Ordinance, this is what a rollout looks like? And do we need to do that? And will we still run into the same issue of certain departments or departments getting legal advice that runs counter to what our intents were in the ordinance?
Well, in a previous conversation, one of us, I don't know, had said, and I think this is good, and maybe this is what we lead with. The ordinance says responses to records requests are to be made, quote, as soon as possible. If the respondent has the record and it doesn't need to be redacted, they should deliver it immediately, not invoke on a rolling basis. Right. So that needs to be top priority.
Right.
And then beyond that, if, they do have to, we also say requesters, have a useful conversation with the requester to narrow or prioritize the request and document production. Requesters should have the ability to prioritize which responsive records they consider most important. And then rolling production should be the default, not only when requested. And to the extent a production schedule can be made, it should be offered. Someone said this, I think Bruce, you might have said this, whose rules apply to rolling? Unless the city attorney has a written opinion, then the code takes precedent. So in that sense, whatever we say, or not whatever we say, what we propose as an amendment, if it were to be accepted, like this would then create a new standard. Yeah.
Yeah, legal counsel's advice, like an attorney-client privilege, attorney-client relationship, it's just advice.
Yeah.
Whether they, the respondent would choose or the client chooses to follow it or not is their business. I'm sure that the city attorney makes a very clear, assertion. Don't cause us more lawsuits,
Right,
kind of thing.
right. I think we've got a lot of what we need here. I think it's just about figuring out what we need to strike from the existing ordinance and then where to add these replacements. But I think we're close to having what we need.
Yeah.
Okay, before we move on, I will ask, do we have any public comment on, I believe we were just on did we talk about immediate disclosure request before, or was that just now?
That was just now.
Okay. Any comments on custodian of a public record, immediate disclosure request, or rolling production?
Mr. Pilpel has his hand raised.
Okay, I'd like to hear from Mr. Pilpel. We got some clarification that we can't have back and forth, but we can have comments from Mr. Pilpel. So Mr. Pilpel, we invite your comments on these sections.
Mr. Pilpel, you've been unmuted.
Okay, can you hear me now?
Yes.
Okay, I don't know where the advice came from, but I think, again, it's up to the chair to decide how to run the meeting. As to the custodian of public record, I've said before, I would think it better to have all of those obligations be a department head responsibility. If the view is not to do that, then I think that's, I guess, okay. I do think that with respect to immediate disclosure requests, that those could be through the department head or the department head's designee, et cetera. I mean, the entire process for what's an IDR and how it's handled is entirely a creature of the ordinance. And so I think we've got a much better way to deal with that. I do think that, again, department heads should be responsible for an IDR. I remember on the rolling document production or production deadlines, I think Member Wolf's suggestion that the task force somehow be in a position to determine whether a request for some kind of additional extension beyond the 10 or 10 plus 10 or 10 plus 14 days is reasonable. I don't see that that's workable. If their idea is that it may take them 30 days and not 24 days, and the requester doesn't agree with that, by the time that gets to a task force committee and the full task force, far more time, like, 30 or 45 days may have elapsed, which, may moot the entire question. And unless the task force has some authority to use hearing officers, or an individual task force member can make the decision, or some other thing that I haven't thought through, I just don't see that that's workable. I think that could bog down our calendar further. And as nice an idea as it is, and it's not a bad idea, I just don't see that it's workable. So I think we would need to come up with some other alternative to that. I would suggest that in any circumstance where a department cannot meet its legal deadline, 1 day, 10 days, 10 plus 10, 10 plus 14, whatever that deadline is, that the specific reasons for not being able to meet that deadline should be put in writing and signed by the department head, or at worst a deputy department head, but that it's got to get escalated and somebody's name has to be on that as saying, we tried, we can't do that, and here's why. That's my suggested alternative. I do agree that rolling production should be in all cases, but what I don't think we've said, and I'm not sure if the ordinance needs to say it, is that rolling production should indicate which records, because they're often multi-part requests. I'm asking for 25 different things. And if a department says, here we have partial production, on a rolling basis, we'll have more stuff for you in a few days or next week. It's not always clear which records produced are responsive to which specific sub-item within a list. So somehow a response should say, we're providing some documents or records in connection with item 3. Those start at page 5. Some other things in connection with item 5. We have nothing on items 4 and 6 right now, but we're, locating those records and, reviewing them for redaction. That it has to connect again to multi-part requests. Those are my thoughts right now. Thanks.
Thank you. Okay.
We have no one else in the queue.
Thank you. Thank you. Let's move on to records retention requirements. There were a lot of ideas about this. This does start to get a little messy in that, on the one hand, I think we've had lots of conversations where we think maybe we should get involved in this, for clarity and consistency. Or are we asking to take on a level of responsibility?
Excuse me, please.
Yes.
Member Wolf is no longer online.
Oh,
We do
no.
not have a quorum.
We do not have quorum. Let's pause the
time
meeting.
Is 7:22 p.m.
Okay, let's pause the meeting and if you could let me know if he appears soon and then we can restart. Otherwise, we will have to end.
One moment, please. We have a connection. Let's see if we can hear from him. Member Wolf, could you?
Yes,
please?
yes, I'm here. I lost my internet for a moment.
We have quorum.
Okay, thank you. So I was saying, moving on to the records retention requirements, on the one hand, I think the task force has lots of ideas about how this could be done better and more consistently. But then the other question is, do we have the capacity to take on this responsibility? I suppose, there are ways that it could be written into the ordinance where, it becomes the requirement. And then we're not necessarily there enforcing it unless someone makes a complaint. So it's not that because we don't have the capacity to go around to every department and say, are you doing this? Are you doing this? Member Anderson, what other thoughts do you have on this?
I agree with you that we don't have the capacity to enforce this. We can just say, we're here to raise the issue. You can raise the issue here, as well as with the individual department. And what that means, who knows?
Yeah.
It still gives another way for a hearing on what's going on as far as retention.
Yeah. Should we step up and try to set new city standards?
What are we discussing here?
Oh, records retention requirements. Should some of these requirements be written into the ordinance?
Aren't they already in the charter?
The retention requirements?
Yeah.
Let's go visit the charter and check on that.
I thought maybe you can allow Mr. Pilpel to open his mic because he may have the answer readily.
I guess can I ask Mr. Pilpel as a?
Yeah, we've done this before where we've had, just an open discussion with, certain people.
It's a
Just
little
trying to-
challenging because he is a member of the.
No, he just won't vote. That's all. He can be part of the discussion. Why not?
I don't know that that's true.
We've done it before. We've done it with members of the public.
At times, the Board of Supervisors has invited guest speakers.
Okay, we'll invite Mr. Pilpel as a guest speaker. Mr. Pilpel, do you know in the charter where records retention specified in a specific part of the charter?
Can you hear me now?
Yes.
Yes.
I do not believe that the charter speaks to records retention. It's Chapter 8 of the Administrative Code. There are some sections there, I could pull them up if you need those, that speak to records retention. There are other provisions in state law in the government code about records generally, to the extent that they're inconsistent. I think under a home rule theory, the admin code provisions might prevail. In any event, it's the admin code, and it generally provides that records are to be classified as to type, and that their retention and destruction schedules and policies shall be prepared by each department, signed and approved by each department head, board or commission, where there's a board or commission overseeing, and approved by the controller as to financial records, the retirement system as to payroll records, and the city attorney as to legal matters. That's my general summary. And I think I've commented before that 67.29-7 really just reinforces that without adding any new specific provision, unless you want to read, professional and business-like as a requirement. But it did not overlay any new specifics about records retention. We've talked before about whether or not the task force wanted to or should have a greater or different role in record retention practices of the city. I'll leave it at that.
What about section 1.109?
Of the admin code?
Oh, no, I'm sorry. That's campaign code. I'm sorry.
Yeah, it's Administrative Code Section 8.3
Yeah.
requires city departments to establish specific retention schedules for records, distinguishing between current and storage records.
And interestingly, the baseline is 5 years, but they say current records and storage records less than 5 years old may be destroyed or otherwise disposed of if their destruction or other disposition within a shorter length of time will not be detrimental to the city and county or defeat any public purpose, and if a definitive description of such records and the retention period applicable to them are set forth in a schedule for the systematic retention and destruction of records that is prepared by the department head, approved by the mayor or the mayor's designee, blah, 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 or the board or commission concerned, and approved by the city attorney as to records of legal significance. But okay, here's the thing. They're saying unless it would be detrimental or defeat any public purpose. Here's the thing. There are lots of records that I think do get destroyed that are counter to public interest and public purpose. But, these policies have been set and there hasn't been much pushback.
Yeah.
In section 11.4.2 of the charter, oh no, sorry, that's the admin code. There's also, this is under franchise fees.
Uh-huh.
It also speaks to a 5-year retention. At least 5 years from the date such book or record was prepared. Books and records required to be retained. So I think there's a smattering of it in various areas.
Mm-hmm.
Yeah, that's in the admin code.
I'm remembering distinctly Anonymous bringing some complaints to the task force specifically about records relating to the pandemic and the early days of the pandemic and the city having destroyed a bunch of records like exactly 2 years after they were created because it was just part of the policy. And Anonymous's argument being, this is kind of a this is an unusual situation when we might actually want to have the records of how things were handled at this time, and they've been, destroyed swiftly, just sort of as a matter of course. I don't know, that moment stuck with me because it did seem like a time when it might have made more sense to hang on to records a little longer.
Mm-hmm.
And that 2 years was not enough.
Yep.
If I may,
Yes, please.
that is a great example of why having the task force with a greater role are either in Chapter 8 or elsewhere as relates to record retention policies and practices may be in order. And that, again, might be a trade-off for other functions not being done or reassigned, and bearing in mind the task force's workload and what's, reasonable.
One thing I would note when we were talking about rolling production and the idea of, excuse me, I think the primary thought is that if we can provide better guidelines for requesters and responders to communicate with each other about how records will be produced, I actually think we don't need to get in the middle of a lot of this. It's just about clear communication and understanding when there is a sense of urgency and when somebody, can wait and isn't in a hurry or is more curious, but it's not they can wait patiently and it's not a big deal and they'll agree to that.
But this is retention. I mean, that's not delivery. I think.
Oh, sorry. I was just going back to, the reason I brought this up was the capacity issue, like what we have the capacity for. And thinking about, if we're saying we want to be involved in decisions about whether an extension can be made and records produced on a rolling basis. Ideally, we're not involved in most of those decisions because there's an agreement that's made between the requester and the department that from which the records are being sought. In instances when there's a disagreement, how would we be able to handle those when we don't even have, are we meeting, is there a committee of the task force meeting on a weekly basis? Like, would we be able to respond to those requests fast enough?
Well, no. But I think
develop a committee.
well, but I mean, you can if there's some reasonable level of guidelines, you can put it, at the discretion of the chair. You could even put it at the discretion of the administrator. I mean, however you want to do it. I mean, it's how much management control do you want over making those decisions? And if we can work as a full task force to develop a good set of guidelines, then, it could be put before the rules committee to develop. And, and then you just follow the guidelines. Kind of how the Ethics Commission does it with their investigation department. The commission creates the guidelines, the department or the investigation unit follows the guidelines.
Yeah, that's actually, perhaps that's a way of doing it right, either with the administrator saying, yes, this is straightforward, or no, it's not, or perhaps there even becomes a new role on the task force, or maybe the vice chair takes on that
Sure.
responsibility where that person fields those requests, or yeah, or there's a new role. Maybe it's something that's rotating, where different, I don't know, thinking about ways that it could get done efficiently and effectively and not slow things down.
Sure.
If I may.
Please go ahead.
Okay. I think the language on the last bullet, bottom of page 3 and top of page 4 is helpful, and that can get tweaked.
Can you tell me what you're talking about? Because I've taken notes and things aren't in the same place that they started out in.
Okay. In the packet, the bottom of page 3,
No,
there's
if you could read some of the words.
Sure. The require ongoing updates and communication with requesters require the following.
Okay, thank you.
6 bullets.
Yep.
Okay. I think that was all in response to the very legit and often expressed concern from petitioners that they weren't getting and don't get consistent communication from departments about the status, and they may get a response or a document the next day on an IDR. They may get something on the 10th day to a regular request. They may or may not get a request for clarification or prioritization, that there's no specific requirement now to communicate on a regular basis about what's going on. And that 4th bullet, periodic updates on work and records production, et cetera, that this was all about improving communication and requiring that communication between requesters and respondent departments. And I would suggest that something like that be included, and only upon a complaint from someone to the task force that the communication was insufficient or their priorities weren't taken into account, or that that a department wasn't applying a reasonable amount of effort towards production, et cetera, that those things the task force would hear as a complaint. I don't know that the task force would want to empower a single member or the administrator or anyone to adjudicate those sorts of things. I think if it's a fair complaint, then I think we treat it as a complaint. But before we do all of that, this beefing up the communication and really requiring more of an effort would help. And to the extent that someone says, I really want all of these documents because they're not quite sure what they want, and a department says, okay, we can get you all of this stuff, but it's going to take a long time. What do you really want, or what's most important to you? And they say, oh, well, the thing that's most important to me is blah, blah, blah. And in general, I'm really just looking for this sort of thing. Then a department representative can say, oh, okay, I understand what you're looking for. Give me a day or a couple of days, or let me talk to whoever. And I think we can get those things pretty quickly. And then if it turns out you really want, the full enchilada, that'll take us a while, and you understand that, but we can get you the stuff that's most important to you sooner. That's the reasonable communication that I think we all want. And so putting that into ordinance language, I think would help. Does that make sense? Thanks.
Yeah, I think that's why we have it here, because I think there's agreement that that would be helpful. So yes. And I think what you're suggesting, and correct me if I'm wrong, I think what you're suggesting is that we not take on the role of, if you're not getting what you want, you'll get a quick decision. you're essentially saying if this process breaks down, your recourse is to file a complaint. Is that correct?
If you're asking me, I would say yes, let's try that first because, you know, I
Okay.
let's see how workable that is. Sure.
Here's the interesting thing about this. Like we think about, you know, what might work, what might not work. Let's try this. This isn't, if we're asking for amendments, this isn't a let's try this situation. I think the let's try this works when we're talking about our policies and procedures. That's where we have the flexibility to say, let's try this. If it's not working, we'll change it again. I think anything that we're recommending to change here in the ordinance has got to be stuff that we're really confident needs to be changed.
Exactly. And I think we have to keep in mind that we don't get that many of these requests for information and records don't even rise to coming to our attention,
Yeah.
that they're being done all the time without much problem, and that there are only a certain percentage that we get. Because given the numbers of requests and we do get some of that information
Mhm.
about the numbers of requests, we only get a very small percentage of those.
Mhm.
So maybe it's not necessary for some of these things, because again, we have to keep in mind that we get a small percentage of all the requests that are out there, and that those are flowing through the systems fairly easily. Or
Yeah.
people are happy with what it is they're getting.
We don't hear about things that work.
No, we don't hear about things that work. We only get the ones that don't. So I don't think we need to borrow trouble.
Mm-hmm.
And I don't know
Yeah.
if we need to be this specific, because again, if most are getting what they need, then the system is working.
I might fall somewhere in the middle, which
Okay.
is I do think we can clarify and give some more examples and talk about, I think it would be helpful to say, clear communication about what's available now and what might take longer. Confirming about prioritizing production, because that's something where I think when you talk about what we see that isn't working, when we see those things again and again, maybe it is worth flagging that. But without giving too many instructions, because a different department might handle it a different way.
Or again, think of it in terms of our education and training component to the different departments, just saying, hey, it would be great if you did this, this, and this.
Yeah.
But again, we can put it in, but we may want to put it in, get the information out there, but maybe not in the form of something added to the ordinance.
Right. I think too, in terms of our intake form and how Member Stein put a lot of work into revising that, which I think has made things, I'm hoping, has made things easier in terms of getting the information we need from petitioners. And that was something, again, not written into the ordinance, but was sort of a change in our procedures.
Exactly.
Yeah.
If I may,
Yes, please go ahead.
I want to reinforce part of what Member Anderson just said, as I understood it, that the city gets tens and hundreds of requests a day, thousands a week, tens of thousands over the course of months or a year, and we get relatively few complaints and spend a fair amount of time on each one. I believe there are some number of requests that are routine and straightforward and are probably responded to perfectly. And just as there are meetings that are handled perfectly, I think that the vast majority are handled fairly well enough, good enough for government work, as they used to say. And that's fine. Are they perfect? Maybe not. You know, maybe there was an IDR that was 2 minutes late, but they got the stuff and that's fine. I'm not particularly concerned with those first two categories. I'm far more concerned with things that are irregular, problematic, or more significant. And I think those are the things that the task force has tended to spend its time on and should continue to. And I guess I'm less concerned about making something that's pretty darn good perfect, and more concerned about making the things that are more problematic or significant highlighted and figuring out how to deal with them. And so I would prefer that we continue to have as much capacity to deal with those problematic and significant things, and not try to fix every little bit. Because most people actually get what they want, and that's okay. Thanks.
Until they don't. Until they don't.
Right.
You know, and then you end up wishing that you had made the change in the code.
So speaking of specific changes, if we're looking at this records retention requirement, this is, and I think I recall that we came to an agreement about this in a previous meeting where we said, you know, adding a minimal retention requirement, that all city records must be retained for 2 years. So that would speak specifically to Chapter 8 of the admin code, and essentially saying we're asking for this modification because right now it says 5 years unless the department comes up with a different policy.
And within the admin code, as it's written by the city, it looks like 2 years is the minimum.
I thought I just read something that said 5.
It says 5, but for emails and things, it's like 2.
Well, and in fact, I thought it made it even sound like it could be less than that, unless maybe I missed something there.
Let's see.
If I may,
Sure.
I think perhaps the distinction is how a record is defined. That if we're suggesting that a record as defined should be retained for at least 2 years, and you could argue 3, 4, 5, etc., that's different from you have to keep everything, including things that are not defined as records. So, you know, phone message slips in the old days, your wife called, there's a problem at school, grocery lists, things like that were never defined as records. And I'm generally okay with that, but that anything that has value for public purposes, something like that is a record and should have a minimum retention time period. Does that make sense?
Yeah, I'm just reading. Oh, huh.
I mean, for example, again, if I may, you may recall that the couple of cases that the task force has heard regarding the assessor's office, there's specific weird state law in the Rev and Tax Code that defines certain documents that they have as not public records, and that runs counter to the general idea of a public record. It runs counter to all kinds of things, but that's state law that defines those as not public records, right? So what we think of as records, if we can, should be thought of as broadly as possible, again, except for those things that really are sort of, personal notes among family. If it's something that's related to the conduct of public business and is created or held by a public agency of the city, then that should be defined as a public record and kept for some minimum retention period. I mean, unless some department is, going to tell us that there's some good reason why something that they do maybe shouldn't be kept. I can't think of that offhand. Thanks.
Okay, thank you. I just wanted to add that under, at the Board of Supervisors website, there's a records retention and destruction schedule. It goes back to 2014, but I assume it would still be relevant on most things. But there is a definition of what a record is in there.
Well, the ordinance has a definition in the beginning of 6720, where it says, quote, public information, unquote, shall mean the content of, quote, public records, unquote, as defined in the CPRA, whether provided in documentary form or in oral communication. So are we talking about the retention of public information, or are we talking about public records?
If I may.
Before you jump in, so also in the admin code, section 8.4, which actually follows some of the discussion of what needs to be kept, they talk about current records, storage records, and permanent records as 3 different categories.
Yes, there is that general distinction of record classification. There's also record type, and perhaps Member Anderson notices in the Board of Supervisors schedule, there are payroll records and legislative records and all kinds of different, groups and classifications of records. I believe the definition of a record for purpose of record retention laws may be slightly different from the definition of a record in our PRA and Sunshine rubric as to record production. It's a much more complicated field than it might appear, is my point. And they came up in different ways. So the development of these laws was not exactly in parallel. That's all.
Yeah, they did it on a rolling basis. Pun intended. So the other thing is, are we talking about I think I'm going to repeat myself, the retention of public information or the retention of public records?
Are you making this distinction because certain records or information may exist in like multiple copies or versions, so the information may be retained, though certain records may be destroyed?
Well, record is a thing. It's a medium. So the information could exist on a piece of paper, in an electronic record, on a CD or a thumb drive or something like that. The question is whether that physical medium should be retained versus the information itself. Should the information exist in, no matter what, in perpetuity, but you may have scanned it in and now you have it in electronic format and you don't need the piece of paper anymore.
Right.
So you can, shred the paper. but you keep the information.
Mm-hmm.
So, that's another element of this, I think, too.
If I may.
Sure. And then I want to move on to the next thing, but go ahead.
Okay. And I'm noting the time. We may or may not want to include encouragement or support for, just as Member Wolf suggested, conversion of paper records to a digital format, particularly if that digital format is scanned and searchable, and if it's, properly referenced and indexed. I suspect that there are lots of records that are still all over the city on paper, in boxes, not well labeled and not easy to find. And digitizing and organizing that is a multi-year important project that has no funding and has no sponsor. And some of that is probably darned important, and some of it may well be stuff from a long time ago that really isn't important. That's, there could be old case files for social services, I don't know what, or health things that are long ago from people who aren't around anymore, and, doesn't need to be kept. I don't know. I'm just saying that there's no meaningful coordination of what's important and what should be kept and how to organize it so that you can get at it. And so I don't think it's as simple as keep everything, even if you can't find it, as opposed to, keep nothing and be able to find it instantly. Neither of those seem like good choices.
What do we think of this bullet point we have here about amending the administrative code so that when any department is reviewing amendments to its retention policy and schedule, that the department must notify the Sunshine Ordinance Task Force, and the task force should have approval authority or be given an opportunity to review and comment on changes to retention policies and schedules?
Without question.
So you like this?
Yes.
Okay.
I'm thinking, since we've had this long discussion on
Yeah.
retention, because this impacts another part of the code,
Mm-hmm.
and may be an issue, are we putting this in here as something that if we're negotiating for our other changes we want to make, we can say, okay, well, we'll give up this retention?
You're saying, are we padding the?
Yeah, because I think of all the things.
Like, we'll give this up if we get the other things?
Exactly.
Oh,
Because
you're talking about negotiating points. I get it.
Because the fact of the matter is, as we've discussed this, there are many moving parts to what goes on.
There are many moving parts, yes.
Yeah, bargaining chips.
That this has anything to do, well, it has everything to do with Sunshine and the fact that we want to make sure records are available.
Yes.
But it really doesn't have anything to do with Sunshine and the fact that this is kind of an administrative process.
This is a very good point.
So why are I think we spent enough time on this. We can put it in, but again, negotiating part.
Right. You're essentially saying if other people are like, oh yeah, that's a great idea, and they want to take it up anyway, great. But if they're like, no, we can't do this.
Yeah, I can't be spending a lot of time on it.
Okay.
I think we get so much, it's like, yeah.
I think we are going to have to discuss what's non-negotiable
Yeah,
also.
and retention is not up there.
Okay.
We've identified areas, and we aren't really in the heart of doing retention. So I would imagine that there are many other factors that come into play when it comes to retention of records, and whether or not all records should be retained and where they should be retained and how. So
Yeah.
I would say we since we've only got 2 minutes left.
Maybe we should move on.
Yes.
Okay.
Call for public comment.
Okay. Let's call for public comment.
Mr. Pilpel is the only individual in the online community, and we have no one in the room.
Okay, well, he's been offering comment along the way. So, Member Pilpel, actually, I guess we're at 8 o'clock now, and I said we would stop. So, can I just ask one sort of roundup last question? So from the ability to amend the ordinance on down, this was the area where I didn't, you can see I left the notes and didn't adopt all of these things because some of them, I think we were still debating, some of them, it wasn't, or we just need to do more work. For example, clarify descriptions of policy bodies and passive meeting bodies, as Chair Yankee noted. If there are discussions happening at the streamlining committee that would affect this, maybe it's not worth us going through a lot of trouble if it's going to be redirected anyway. So I think these are still open-ended things.
Are you saying that certain points like that we would just buckle and concede to?
No, not buckle and concede to, but we need to know do we need to know what is happening in other corners, or should we proceed as if those things aren't happening, come up with our best approach, and then see if these approaches collide?
Oh yeah, absolutely.
Okay.
Absolutely. I wouldn't try to, do a wait and see what they do before we send in our thing. No, we send in our thing.
Okay.
And then when the Board of Supervisors say, okay, we've got, these two things are in congruence. Okay, we'll agree to those. These two things are in conflict. Now we got to have a longer discussion. And they'll bring us to the table, hopefully.
Okay. We've made a little bit of progress. Unfortunately, maybe next time what I want to do is, so you guys are meeting next Wednesday. I will not be here. I may try to, actually, I need to find out whether I can call in and participate as a, just a comment. I don't know what you're hoping to do at the full task force. I mean, I guess the question is, should I take another stab at this? Maybe refine these summary items one more time and then perhaps produce a clean version of the ordinance, maybe highlighting the sections that I think we're talking about making the line edits to, just so people can see which areas we're focusing on without doing the things like, update state code references throughout, which is something that, we can do at a later stage, and that's a find and replace thing.
That seems reasonable.
And then there are the things about add references where the Sunshine Ordinance aligns with CPRA and Brown Act throughout, and note where it expands rights. I mean, that's gonna be a lot of work, and I don't think I am the person to do that. So
let me ask Mr. Pelpel, who's still on the line. Do you have any idea when the city plans to put up the charter amendment? Maybe a main big one?
I believe that there are February 1st and March 1st deadlines for the commission streamlining task force. One is for the final report, and the other is for any proposed ordinances and charter amendment. The general deadline to introduce a formal charter amendment is usually in May, and the final deadline to place it on the ballot is usually the end of July, beginning of August for November. I suspect that slightly before and during the upcoming difficult budget season, there's going to be a lot of talk about ways to streamline, ways to restructure, what things have to go on the ballot, what things can be done without, et cetera. So I think that timeline is still being developed. And
You don't think they'll try? You don't think they'll try for June?
No, I think there are, and Victor would know for sure who's on the call. But I think there are only a couple of ideas that are being possibly kicked around as charter amendments or other possible ballot measures for June. But I don't foresee right now June as being a significant election for all of that.
Okay.
If I may just very briefly, perhaps
Sure.
we could discuss at the full task force the ability to amend the ordinance and the pros and cons on that. Maybe some of the SB 707 and other things. I mean, just to give a very quick example, the idea of advisory bodies, that's been discussed to some degree at commission streamlining. There's a new definition in SB 707 about subsidiary bodies. If we were to consider the concept of an advisory body that can merely make recommendations to a department head or to some policy body, but has no final decision-making authority, right? Just as a concept. I think that kind of an entity should post a meeting agenda and take public comment and perhaps have minutes, right? And maybe we would require that an audio or a video recording, if there is such, be posted within a day or two on a public website, easily accessible. But we might at the same time say that they don't have any provisions for closed sessions because an advisory body has no reason to go into closed session. And maybe there's some other things that normally apply to a policy body that we wouldn't impose on that kind of an advisory body, because the whole nature of an advisory body is to get public input and make recommendations or report to some other body that's going to consider it. So it's that kind of thing where, there may be some flexibility and levels that are applied here with less rigidity than exists now with respect to all policy bodies or everything that's a charter board or commission. That's just an example. We could discuss that at greater length. Thanks.
That's an interesting idea. So to ask Ms. Peterson, you said that the agenda at the next task force meeting is quite lengthy.
It is, and if there are any attachments associated with this update, I would need them very soon, early Friday morning.
Okay, so much fun. It sounds like then offering Chair Yankee maybe some guidance on a couple of topics that would be helpful for the full task force to discuss where we haven't necessarily sussed it all out would be helpful. And maybe some of those being ability to amend the ordinance where I think there's not consensus, SB 707, which I think would be useful also in terms of educating the task force. And then advisory bodies and how the Sunshine Ordinance may apply to them. Member Wolf, does that make sense?
Yeah, I think that's reasonable.
Okay. Anything else that anyone would want to add to a very short list that may get truncated depending on how late you guys are going? Sounds like, oh, go ahead.
I don't think so. If the meeting's going to go, it's going to be a really heavy agenda, then, I think prioritize what we think should be discussed.
Okay.
Because it's at the end of the meeting and everybody's already, petered out.
Yeah, I will look at this list too and see if there's anything that seems like it really needs a discussion because we haven't, maybe it's toward the end and we keep not getting to it. I'll see if there are any of those that maybe wouldn't take as long, but would benefit from some discussion.
Okay.
Okay.
Go ahead. I have something extraneous to say, but I'll wait.
Why don't you wait till we get to the next? Is it
Yeah.
related to the Sunshine Ordinance specifically?
No.
Okay.
Yeah.
Let's call for one last final public comment. Even though I think we have one commenter. Mr. Pilpel, would you like to make a final public comment before we call the next item?
Yeah, just one thing, and it touches back to a discussion from a few minutes ago. Perhaps the interest and willingness of the task force to take on a greater role in record retention policies and practices,
That's interesting.
and more slightly more broadly about intention and capacity and priorities for the task force. So if, like if we were starting over, or if we got to choose, how much time would we want to spend on complaints and complaint resolution? How much time would we want to spend on policy or reviewing departmental practices or things like that? So to the extent that there are desires of the task force that are frustrated by the current structure, are there ways that we could amend the ordinance to, get to a better place for all? I don't have an answer, but it might be an interesting discussion. That's all.
Thank you. Let's call the next item.
Item 8, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
Member Wolf, does your comment fall into this category?
Yes, it does.
Okay.
I just want to mention that I forwarded the document that outlines what we were trying to consider with regards to the museums.
Mm-hmm.
The internal memo. I forward that to Ms. Peterson and to yourself, Chair LaHood,
Thank you.
For distribution between us members here in this committee, because I think it would be enlightening.
Thank you.
And I don't recall if the task force resolved to release it publicly, because it was back in 2021. We may have. I don't remember if we did or not.
I do not recall either. I think that's something that would have to be researched.
Yeah. Okay.
Okay. Members, any other items for future discussion?
May I not, as a new item, but to just remind on something from earlier? Two things.
Related to this discussion, or
Yes.
Go ahead and say it, and then I'll decide if it should be
Okay.
or not. Go ahead.
If we can find that city attorney communication on what they were and weren't willing to do on the SOR issue, and I believe at the beginning of the meeting, or the beginning of the previous item, Mr. Dworetsky had something to provide to the committee. If we can put that in the file and circulate that.
I was just going to ask Ms. Peterson to scan that in for the file. That would be great. When you said SOR issue, what are you talking about?
Supervisor of records. I apologize.
Oh, yeah, acronyms.
And if we could
spell it, you got to spell it out in the first reference, otherwise nobody knows what you're talking about.
Apologize. And
but-
if we could circulate the Dworetsky thing prior to our next meeting, that would be great.
Yes, I think that's a good idea.
Thank you.
He essentially he paraphrased it into the record, but yeah, I think it would be helpful to scan that and share that with everyone.
Thanks very much.
Anything else? Thank you all for being here. I'm sorry that I will miss you next Wednesday, but
Happy New Year.
Happy New Year, everyone. Oh,
Move
item
to
9.
adjourn.
Yes.
Item 9, adjournment.
Move to adjourn.
Okay.
The
All in
committee-
favor?
Aye.
Thank you, everyone. Thank you, remote participants. We appreciate having you here.
The committee is adjourned at 8:15 p.m. Microphones are off.